Well, welcome everybody to our first Hot Topics event of the year. As is tradition, what's wrong?
You couldn't help yourself with a hot topic.
Well, sorry, it's just
It's true.
Yeah, it is true. Anyway, so it is our ongoing effort to reach out to the broader legal community in Philadelphia. We realize that we are doing work here at Penn in the law school that we realize that doesn't always create the same kind of interaction and benefits to the broader legal community in Philadelphia as well as the academic student community here. And so this is our attempt to try to bring some of the issues that we're talking about and some of the issues that are confronting the legal system to you in a nice, compact and hopefully user-friendly form in a way that it'll make your appetite and your interest in the coming year in law and technology that much stronger. A couple of housekeeping notes. I should warn in advance that we are recording this. And so if you have a concern about that, you should know that by staying here that is going to happen for the benefit of the people who cannot come. On a happier note, this event will be followed by a reception outside, which everyone is welcome to join. And whatever interactions you don't finish, we'll have question and answer towards the end of here, but you should feel free to approach all of us and ask us further about these issues or anything else that that was spawned in your interests. Just so you know, this is part of a wide array of programming that we do. In terms of public events, there's particularly on October 11th and 12th, we're doing a major conference on antitrust law led by our own Herb Hovenkamp called the Post-Chicago Revolution. In addition, just so you know, for those who are also the next event like this that we will do in the evening will be on November 18th on privacy. For those of you who don't know, both Europe and California have enacted major privacy legislation, California going into effect on January 1. And the most interesting thing about what we were discussing about California privacy law is the sheer number of entities that will be covered who have never had any obligations to engage in privacy compliance whatsoever. And I see a lot of nodding heads out there from those of you who know. And so your average tire repair shop or grocery store who's never been in a regulated industry from privacy will discover they already all of a sudden have a large number of obligations they didn't need to know about before. Plus the European approach, laws coming into effect and all these other aspects make for a very interesting conversation. Just so you know, we also have a number of student-oriented events that will come on and staff-oriented events. For those of you who find interest in this programming, there is a one-year degree program available to grad students and staff called our Master of Law, of which we have one of our distinguished graduates here in the audience who will be speaking on October 8th. And we'll have an information session for those interested. And for students, we have a career lunch with a patent counsel, Jennifer Ying, on October 15th. So if you're a member of the student body, please, and are interested, please sign up and do that. I'll come see you there. Lastly, if you're interested, before I forget, we do have an email list where we put all these out on a monthly basis. So if you want, please go to our website. There's a link that you can put on our email distribution list and find out about all the things that we do. All right, without further ado, we have a fascinating set of speakers lined up to talk to us today. The first, we have Sean Balganesh, who will talk about copyright, but we'll also have Gideon Parchamovsky talking about trademark, Cindy Dahl talking about patent law, and I will play cleanup, talking mostly about antitrust with a little nod towards a major copyright case called Oracle v. Google, and then the network neutrality decision that was handed down yesterday. Sean?
Great. Well, thank you all for coming. So I'm going to talk about two copyright cases that are before the court and scheduled for oral argument. Only one of them is really a core copyright case that addresses copyright doctrine, and I'll spend most of my time talking about this one, partly because I think it's more interesting, but also because it's really the only copyright case that we really care about copyright doctrine for the court. A note of disclosure, I am on an amicus brief in this case on the side of the respondents, so take what I say about the case with a huge grain of salt for my views on it. But the case is Georgia versus public.resource.org, where the court granted cert around this core question whether this common law doctrine, this doctrine of common law of copyright called the Edicts of Government Doctrine, applies to annotations that are prepared and made part of the official code of Georgia. So to understand what's really going on in this case, which seems to be around a narrow point, it actually blossoms into a whole set of interrelated copyright issues with some fascinating potential legal consequences, all revolving around how expansive the court wants to make the decision. So let's start with some basics on what is at issue here. So at issue here is this doctrine that emerges in the mid-19th century through judicial reasoning called the Government Edicts Doctrine, or the Edicts of Government Doctrine. It comes about formally in two 1888 decisions of the U.S. Supreme Court, Banks v. Manchester and Callahan versus Myers, both authored by a little-known Supreme Court Justice, Samuel Blatchford, who actually is better known for being one of the founding partners of Cravat, Swain, and Moore. But what happens in these cases is the question emerges whether the judicial opinion or judicial report that is produced by the court, occasionally with the officially designated court reporter under a state statute, can be the subject of copyright. Now, the court reporter is obviously appointed under state statute, so one of these cases related to Ohio law and the other one related to Illinois law. They were both questions of federal copyright law, but the appointment of the judicial reporter happens under the state law. And the proposition that the court takes as largely settled by an 1834 copyright case known as Wheaton versus Peters is that judicial opinions cannot be the subject of copyright. They are produced by judges who are employees of the federal government. They're already paid by the exchequer, and what they're saying is the law. And so the court says in Banks versus Manchester that as a matter of public policy, long-standing public policy, the exact words used by Banks v. Manchester, it doesn't make sense to allow the copyrightability of judicial opinions. Now, this doctrine, over a period of time, gets extended and applied to statutes. Now, and therein lies the big question that comes about in our case here with the state of Georgia. Now, an important thing to note, both these decisions, Banks v. Manchester and Callahan versus Myers, are decided in the same term, about 14 days apart, both authored by the same justice. But in Callahan versus Myers, the court says that the statement of the case and annotations that are produced are copyrightable. Whereas in Banks versus Manchester, the court says no. And one of the unresolved disputes is why exactly is that? And I'll come to that in a minute. All right, let's fast forward a century and a half to the age of the internet, when access to the laws of different jurisdictions starts becoming harder and harder to realize, on the one hand in physical copy, but easier through the internet. And along comes this organization, a public interest organization called public.resource.org, run by this individual, Carl Malamud, whose sole objective is to make laws around the world, all forms of codes, all forms of privately created codes, state codes, county codes, publicly available for everyone on the internet. And as part of this project, one of the things that PRO does is it makes a full copy of the official code of Georgia, annotated, available on the internet for anyone to access, for anyone to copy, for anyone to download. And Georgia objects. Now, a couple of things about the official code of Georgia annotated. The Georgia Code is not just the statute of the state of Georgia. The OCGA is also the annotations that are prepared by a company under contract with the state of Georgia that describes the comments, adds commentary, provides case comments relating to interpretations of the relevant statutes. But Georgia has a particularly peculiar practice that they themselves have a hard time explaining, as indicated in their brief, is that the legislature has to vote and adopt the annotations even when they're privately produced. So in other words, the annotations get merged into the overall statute and assume an official status, right? And that's the reason why the only way of getting the official code of Georgia is by getting it through the official code of Georgia annotated. And that's why PRO decides to put the entirety of it online rather than disaggregating the two. The 11th Circuit, and the matter goes, Georgia objects and files a copyright infringement lawsuit, and the matter makes its way up to the district court, and then the 11th Circuit, in a fabulously well-written opinion, finds for PRO, under, however, a largely academic theory of metaphysical authorship. The court's reasoning is that this is not really a work of authorship because the real authors of the code are the people. because the representatives of the state legislature are indeed accountable to the people. So the real authors, if you think about it in the democratic process, are the people who they're accountable to. And as a result, it has to not be uncopyrightable. The court doesn't really grapple with core copyright issues. Georgia tries to get the court to issue cert, and they do. And the court basically grants cert on what seems to be the narrow question of whether the annotations are copyrightable rather than whether the overall Edicts of Government Doctrine has continuing validity. But a couple of things about the case, though, which is in their briefing before the case, the state of Georgia makes a big deal of the fact that, of two things. One, that this Edicts of Government Doctrine, the one on which the 11th Circuit relies, and that really is doing most of the analytical work and doctrinal work in the case, is a pure common law doctrine, right? In the sense that it wasn't recognized in the statute in 1909, and it certainly wasn't recognized in the statute in 1976. So the argument that they're making, which is in many ways, I would say, pandering to the textualists and the textual impulse in the court, is what is the continuing legitimacy of this doctrine? Congress does not even seem to have acquiesced in its overall creation. So in what sense is this continuing to be a valid doctrine that can run counter to what Congress enacted in 1976 on principles of copyrightability? In other words, Congress's silence on the non-copyrightability of state government edicts should mean that they're now copyrightable. That's Georgia's claim in one sense, right? That's the hardest, that's the more extreme one. Now, the other version of what they're also saying is that even though they're voting as a legislature on the official code annotations to adopt them, it is abundantly clear, because the code itself has a provision that says that the annotations do not have the force of law. So the interpretation that the state of Georgia is taking is that for the government edicts doctrine to apply, if it has continuing validity, it is limited to text that has the force of law, not to the annotations, in other words. But their argument about how the annotations get merged into the statute, they claim it's an entirely formalistic thing, that it's done purely in order to suggest that one interpretation, or that this particular company, the Michie Company, has been granted a contract by the legislature of Georgia. So the structure of what they're trying to do is connect the government edicts doctrine to content that has the force of law, not saying that it can apply to things that have official status but do not have the force of law. Which now brings me back to what I said in the discussion about Banks versus Manchester and Callahan versus Myers. Remember, I said that in one case, the court decides that the statement of the case is copyrightable when it's produced by the court reporter, and in the other, the court says, the opinion says, no, it's not copyrightable. And if you look at the nuanced difference between the legislation in Ohio and Illinois in these cases, what seems to be at the root of that distinction is that in one, the statement of the case, even though prepared by the state reporter, had to be approved by the bench. Whereas in the other, the statement of the case, produced by the court reporter, makes its way into the report. And the lack of copyrightability is coming into the picture, again in my reading of the reconciliation of these cases, because the official approval of the statement of the case by the judges in one gives it an official imprimatur. But that has nothing to do, note, with it having force of law. The law relating to precedent, we know well before these cases and well after, does not allow you to cite to the statement of the case as binding. The statement of the case is purely descriptive, analytical understanding. Nevertheless, it is rendered uncopyrightable in one but copyrightable in the other, which goes to show that I believe that this force of law argument, I don't think is the only way of understanding what the government edicts doctrine really is doing. So as presented to the court, we don't have yet the respondent's brief, which I think is due in a week or so. All we have is the brief by the state of Georgia, a bunch of amici briefs that have come out in favor of Georgia, and very importantly and interestingly, the Copyright Office through the Solicitor General has weighed in favor of the state of Georgia, basically saying that it is a form of copyright infringement and that the annotations are copyrightable. So as presented to the court, I think the court has three choices, right? In the way in which it's framed, in the way in which it's cast, and in the way in which it might approach the government edicts doctrine. Option one is for the court to say, what on earth is this doctrine? With copyright law is all about Congress. The Congress has not said anything even acquiescing in the continuance of this doctrine. And remember, it's not as though all of copyright doctrine has to come from Title 17. There are large swaths of copyright doctrine that are entirely judge-made. But the prevailing understanding is Congress needs to have acquiesced in it. The absence of any congressional acquiescence for over 100 years could cause the court to say, oh, this doctrine is just absolutely crazy. It has no place in the copyright universe. I don't think the court is going to go down that road because that would result in this absurd position that laws, state laws, federal laws, county laws, all start now becoming copyrightable, and you can see the absurdity of that interpretation and where that would go. I think option two is to allow the doctrine to subsist and continue, but allow for it to go completely in the direction that the PRO wants. In other words, allow it to subsist, but expand it by treating it as applicable not just to annotations, but to newer wrinkles that have emerged since 1888, which is a position that some are pushing for. So what do I mean by that? A case emerges about a decade and a half ago called the Vec case, which involves the following changed set of facts from the traditional edicts of government doctrine. A privately created code by an industry standard-setting organization gets adopted by that organization. Then, a few years later, and this was the intent behind creating this private code, a local government adopts that private code into its framework of rules and regulations, giving it official status. So even though in its origins it was privately created, it assumes official status as force of law when it is adopted by the government agency. And the court rules that it loses copyright when this happens because the original intent behind its very creation was to have it function as a government edict. So in one interpretation, the court would say, well, we'll allow the doctrine to subsist, but expand it and extend it into the domain of these new areas which are where the rubber hits the road in the modern context. I think this is also unlikely. These are the two extreme positions that I think amici on both sides are going to push for. What is more likely is that the court is going to recognize the doctrine, but limit it using parameters internal to the jurisprudence of these two cases. So what you're going to see, I suspect, is Justice Thomas and Justice Gorsuch sitting and sifting through the 1888 opinion or the 1834 Wheaton versus Peters opinion saying, what does it mean for something to have the force of law? What does it mean, or what did it mean, heaven forbid, for it to have the force of law? What does it mean to have had the authority of law, and should that be a restraining or restricting principle for the government edicts doctrine? Okay, that's Georgia versus PRO. The other case that I wanted to talk about very briefly, and this is not really a copyright case, is Allen versus Cooper, which has an interesting set of facts, which has to do with a underwater videographer, director, filming footage of the Blackbeard pirate ship. And then along comes, I believe, the state of Florida, that for a variety of supposedly public purposes, makes copies of that video footage and also distributes it. So it's not just a violation that is claimed of the reproduction right, but also the distribution right. And the action is brought claiming that the state of Florida is infringing the copyright in the work. Now, the immediate argument is, well, how can you sue a state because it has federal sovereign immunity under the 11th Amendment? So here we get into the issue of an enactment by Congress in 1990 called the Copyright Remedies Clarification Act, which is really a two-section statute, and only one section is really functional for us, where what it says is federal sovereign immunity for states in copyright infringement actions is abrogated. And as the matter makes its way through, the Fourth Circuit and eventually the Fifth Circuit, but this is on appeal from the Fourth Circuit, find this CRCA in this defense of the videographer's infringement action to be unconstitutional. They look at the Supreme Court's jurisprudence under when federal sovereign immunity can be abrogated for states, allowing them to be sued, and says that there are two different ways in which it can happen. It can happen either by reference to the intention and the original convention, or by looking at whether there was a particular harm that was sought to be prevented by reference to Clause 5 of the 14th Amendment. These two approaches are relied on, and I think you have three circuits that conclude that the CRCA is unconstitutional. The big question for the court is whether the CRCA indeed meets the requirements of a valid abrogation. Copyright is sort of peripheral to this question. It's really all about the structuring of the statute, what kind of harm the Congress was reacting to. And the question I think that might come up is how pervasive is state infringement of private copyrights? To the extent that the court decides to go down the road of saying, was there a harm that Congress was specifically choosing to remedy through the exercise of Clause 5 of the 14th Amendment, I think it will ask for some extended proof of harm in order to validate this statute. Again, unclear how this is going to come out, mostly because I don't think it's about copyright. It's going to be about the court's sovereign immunity jurisprudence. All right, thank you.
Well, thank you, Sham. And for all of us who follow the court's sovereign immunity jurisprudence, it is not, shall we say, a model of clarity. So, anyway, we will proceed to Gideon.
All right.
You can sit there and do this. You can stand up.
Thank you. Yeah, I'll just stand as I normally do. So, welcome. Thank you very much for coming here. And let's talk some about trademark law. And we also have two cases. And here they are. First of all, and that's probably the more important case of the two, we're going to talk about what the Supreme Court decided to do with the bar that prevented registration of immoral and scandalous marks. And I think that any person who follows trademark law could see this case coming because it had to. And we are starting with a different case, Mattel versus Stam from 2017, that pretty much started this domino effect. And in this case, the Supreme Court ruled that the Section 2A bar that prevents registration of disparaging marks is unconstitutional because it conflicts with the First Amendment. It's viewpoint dependent, and the Supreme Court applied the strict scrutiny standard and determined that the government failed to show the necessary state interest, nor did it manage to show that this bar was narrowly tailored, so the disparagement bar was out after that case. All right. This, of course, raised the question.
And most interestingly, in the spring of 2017, they actually performed in the law school upstairs at an event we sponsored, which was a lot of fun.
Right. And after today's session, I will perform. And it will not be fun. I suggest that you run to the exits. But before you do that, let me talk about the following case. This is the case that I just mentioned. What was so interesting is that, well, it was in a way surprising because we have those bars since the enactment of the Lanham Act. It goes back to 1946, and no one thought about challenging those bars until someone did. And what was interesting about the 2017 case is that it was a case of reappropriation, and that meant a lot. And along comes the case that we are here to talk about, Yonko versus Brunetti. Much less heroic, I would say, and my main challenge is to talk about the 2A bar without, that would be my personal challenge, without using any inappropriate language, although probably nobody cares, but I'll try. So Brunetti sought to register the term FUCT. The USPTO denies the application on the ground that this term is scandalous or immoral under the 2A bar. And it seems like a pretty straightforward decision, except it wasn't. So I think that the majority opinion penned by Justice Elena Kagan is the one that makes most sense. She viewed it as a straightforward case, a continuation of the previous case, and I think she got it exactly right, although people can disagree with me. According to Justice Kagan, the immoral and scandalous bar discriminates based on viewpoint, therefore it collides with the First Amendment, and it must therefore be invalidated as it disfavors certain ideas. Turns out that not all the justices on the court viewed it as a straightforward case, definitely not as a simple case, and several justices decided to write separately, and I think that of the various dissents there, they all share the same themes, but the most interesting one was authored by Justice Sotomayor, and she made several arguments. The first one, which I think is very interesting from an analytical standpoint, is that the majority collapsed the two terms in that section, scandalous and immoral, treating both of them as one and the same, and they are not. She suggested that we can draw a line between ideas and the mode by which they are being communicated, and scandalous refers to the mode of communication. And according to her and several of her colleagues on the court, there was no need to completely eliminate this bar, to scratch it out. We could have engaged in a much more nuanced approach, and several of the justices suggested that because they thought that sometimes the mode of communication is not so outrageous. In other cases, it is. And I must say that while this approach is consistent with our First Amendment jurisprudence, I don't see it as very promising. I really don't see a way out. I don't understand how this distinction between ideas and modes of communicating them does a lot of work here, how it is going to help the court out. What is very scandalous to one person may not be very scandalous or immoral to another person. The entire First Amendment jurisprudence in this area is in need, in my view, of reassessment. We still rely on community standards in other contexts in the age of the internet. What community? What standards? I mean, the Supreme Court has the answers. Now, I do understand, by the way, that for justices it's a wonderful world. Why? Because you have all the discretion you need, and yeah, you can apply it, and I think that they are acting in good faith. I have no complaints about that. At the same time, I don't think it is very, very promising. But I wanted to go beyond the decision, with your permission, and spend a little bit, just talk a little bit more, spend a little more time about the possible implications, and also show you a few things. So, look, guys, it was a very interesting law review article by Barton Beebe and Jeannie Fromer, both of them from NYU, and I think it's quite interesting. So they looked at 3.6 million registrations, okay, not 3.6 registrations, but 3.6 million registrations, all from 2003 to 2015. And you might ask yourself, so what will be the effect of this decision? How many of those applications were struck down because they were viewed or deemed as immoral or scandalous? Now, are we going to see an explosion of new registrations because this bar was removed? So, it's hard to tell. Of this data set that they put together, about 1,900 rejections were based on the immoral or scandalous bar. So, not that many. Not that many. 2,000 out of 3.6 million. Is this the total amount? The answer is that we cannot know. We don't know. It is possible that there were many other businesses, individuals, who had a mark that they wanted to register but thought, nah, it's not going to pass. And what I think is really interesting about the work that Beebe and Frommer did together is that they suggested that this bar could not stand for a different reason, that it doesn't even meet the intermediate scrutiny test under Central Hudson because it is narrowly drawn and arbitrarily applied. What is arbitrarily applied? You might think that, well, it's pretty clear what is immoral or scandalous and what is not. Okay, have a look. So, what is this?
French connection.
French Connection, right. When I first saw it, I, of course, read it the way they wanted me to read it. It's like, really? Seriously? I mean, and it's hard to help it. So this is just Exhibit A, but there are several other examples, and credit
This was
should go-
registered?
What?
This one was registered?
Yeah. And credit should go to, again, Barton and Jeannie for doing this. So here are some examples. So Brunetti's mark, so-called, or term, will join this glorious family of other marks, and some of them were allowed, others were not. I don't think you need me to read them out loud, especially since I have this personal challenge of avoiding saying those words, but people are smiling. You're very capable. You're much better than me. You don't need me for that. Now, the last one is actually pretty annoying because the PH you see there, PH you see cancer, it stood for please help us cure cancer. So what do I know? I mean, is it immoral? Is it scandalous? Guys, you decide. Now you can see why I think that Elena Kagan, Justice Kagan, had it right. I think that it's a dead end once we start applying our moral judgment to trademarks. It's not going to work so well. All right, but since I'm facing time constraints, allow me to share some thoughts. So, what would be the effects? And we can talk about the narrow effects, the effects that would be confined to the realm of trademark law. And I see many of my students here, so special greeting to you. And there will be two effects. The first one is on registrations. So how many new registrations will we see? And that brings me back to another important paper by, again, Barton, Beebe, and Jeannie Frommer. They produce good papers. They published the paper in 1218 called Are We Running Out of Trademarks? Turns out that most terms were appropriated, and now even scandalous, so-called, or immoral terms will become registered marks. And the second effect, and I don't know whether the set is limited to about 2,000 words. I'm pretty sure that there will be a lot more. Please keep in mind that immoral, scandalous marks do not have to be verbal necessarily. They don't have to be words. They can be gestures. They can be visual. And the sky is the limit. Plus, keep in mind that you can combine words and combine words with art or whatever you call it. Doesn't matter. But it will be interesting. I think that I already said it to my students. This is a nice area to consider writing a note in or about. It could be interesting and entertaining. Litigation. That brings me back to the previous slide. Okay, I mean, look, we already have those marks. What will happen to Brunetti's mark the moment it is registered or used? Could other people sue for infringement? Wow, yeah, I would think yes. Pretty soon some of those marks will become famous and then there will be suits for dilution. That's what we will see there. And it's not because the Supreme Court got it wrong. That's the nature of trademark law. And finally, about this case, effect on free speech. So the Supreme Court removed the 2A bar in the name of free speech. And I do not criticize the Supreme Court. But what I think is very, very interesting is that there could be some unintended effects, and they can be counterproductive from the perspective of free speech. Because, look, something that you must understand about the Section 2 bars is that there were bars to registration, not to use. Not to use. Anyone could use immoral terms. No one could register them. This means that in the past, each and every one of us could use any of those terms that were not registered, right? No one had exclusivity over their use. Now, I'm not just talking about businesses. I'm talking about real-world artists who could express certain ideas that, may be shocking to us or to me. But as I always say, who cares about my opinion? This is not what free speech is about. It's not about what I think. It's about free expression. Now, when those terms, those concepts can be appropriated, it will narrow down the liberty of others to make use of such terms, of such ideas. And if you side with Justice Sotomayor, that's fine, but then it means that you will not be able to communicate them in certain ways. And any way you look at it, I think that the world or the realm of free speech may be smaller after this decision, and that's cause for concern, okay? That's cause for concern, I believe. Great. Second case. Much more technical, much less interesting to most of us, except the lawyers in the crowd. And for the lawyers in the crowd, it is an important case. Romag Fasteners versus Fossil, a very interesting case here. Fossil used counterfeit Romag snaps on its handbags in violation of Romag's trademark rights and a licensing agreement, which makes the case even more extreme. They had a licensing agreement, and Fossil somehow forgot about it, somehow didn't pay attention to what it was doing, and used counterfeit fasteners or snaps. The jury, Romag sued, and the jury decided to award Romag damages for two elements. About $90,000 to prevent unjust enrichments, and we're talking about profits. That's the key element of the case. And then over 6.7 million, again, in profits to deter future infringements by Fossil. The jury concluded, and this is the most important element, that Fossil acted with callous disregard of Romag's rights, but the jury did not say that Fossil willfully infringed Romag's trademarks. Okay. And that, of course, raised the question that the Supreme Court will have to decide. The case has not yet been decided. The Supreme Court took it up, granted cert, but has not decided the core issue. And the core issue is this. Is willfulness a sine qua non, meaning an absolute requisite that to the award or for the award of profits? Now, why are profits so important in trademark cases? I'll tell you, because, harm or loss is very difficult to prove. How much did Romag lose as a result of this violation? Maybe a lot of money, maybe not, but how do you go about proving it? The profits to Fossil are much easier to prove. Therefore, profits are a very important remedy, and of course, it's an equitable remedy, and I will return to that when I move on to my next slide. And the question is, must there be a willful infringement, or is callous disregard enough? The district court struck down the award on the theory that willfulness was necessary. The Federal Circuit affirmed because this case was litigated under the jurisdiction of the Second Circuit. And as you know, circuit splits is something that calls for Supreme Court to step in and intervene. And I don't think you could have come up with a more perfect split than this. Please take a look at the next slide. This is a 6-6 split. Okay. Willfulness is not required in the 3rd, 4th, 5th, 6th, 7th, and 11th circuits. Willfulness is required in the 1st, 2nd, 8th, 9th, 10th, and DC circuits. So it's time for the Supreme Court to step in and say something, as the famous song goes, just say something. We already said something about my artistic skills and my singing ability. So here is the interpretive challenge, and I will end with this slide. Look, the term willful is expressly mentioned only with respect to dilution claims under Section 14C. It does not appear with respect to other causes of action under the Lanham Act. And this is the question. So should it be treated as an exception nullis, as a negative arrangement, or, well, all causes of action should be treated in the same way? What will the courts do? As Professor Bogan said earlier, it's hard to tell. I mean, if people could predict what the Supreme Court could do, they'd be very lucky and fortunate. I'm lucky and fortunate, but I cannot predict what the Supreme Court can do or will do in this case. So I will just say that it is widely accepted, that's the conventional wisdom, that the Lanham Act sought to codify the principles of equity. The remedies offered under the Lanham Act, they originate in the law of equity, and the interpretive trend in this context was to maintain flexibility. So, shall I bet or shall I gamble? I mean, shall I tell you what I think will happen?
Sure.
Yeah.
The good news about being a law professor, you get to overrule the Supreme Court every day. The bad news is nobody cares.
Right. So I'll tell you, in my personal view, I think willfulness is required, actually, but as is often the case, I'm not sure that the Supreme Court will adopt my view, and maybe it will adopt the more flexible approach, and we'll leave it to the courts to decide, give them more discretion. I don't know if my esteemed colleagues on this panel agree with me or not, but
it's being recorded.
it's being recorded. No, I know it is being recorded. It's not the end of the world. Thank you very much, guys. I'm done.
Well, the good news is we generally do a year-end wrap. And so you can, once these cases have all been decided, so we can come back and find out. And if depending on how it's turned out, we can revisit this and make fun of Gideon probably in his absence, because he probably will be still in this field. All right? Cindy, if you would take us away on patent laws.
Okay. So I'm going to talk about 3 issues, 2 cases currently before the Supreme Court, and then a piece of legislation that is currently before both the House and the Senate, which has been before the House and the Senate before, but is sort of the most major piece of legislation we have now on potential patent reform, so it merits a little discussion. But first, the 2 cases that are before the Supreme Court. Okay. So the first case, Peter V Nantquest, is a case about a really cool patent that went through the process of getting considered by the USPTO and then eventually denied. It went all the way through the process, and they appealed to the district court under Section 145, which is their prerogative to do. And this is a case about whether attorney's fees should be awarded to the USPTO. So they went to the district court. It was dismissed on summary judgment, and the USPTO had spent about $114,000 in attorney's fees and expert fees as well to litigate this case. So they asked the district court to grant them fees, and the district court denied it. Federal Circuit reversed, and then reversed again en banc. So why could the USPTO ask for attorney's fees here? Well, we have this part of the statute, 145, which is the area of the statute that the patent holder appealed under, which ends with this one phrase that says that basically if you use this remedy, all the expenses of the proceedings shall be paid by the applicant. So what exactly is the meaning of the term all expenses? So are attorney's fees, for example, covered under all the expenses? Is this what was actually envisioned? So a couple of things to consider here. First of all, when you are disappointed as a patentee and you've gone through the USPTO and the Ptab process and you've had your patent denied, you can appeal to one of two places. First, you can bring the appeal to the Federal Circuit, and that is the path that the USPTO prefers because the Federal Circuit rules based on the record that's already been stated. Or you can choose to go to the Eastern District of Virginia. And if you bring the case under the district court, then they review everything de novo. So it ends up being much more expensive for the USPTO. So until the America Invents Act, the USPTO had always interpreted that phrase, all the expenses, to mean relatively minor expenses like travel and copying and some expert fees. But under the AIA, the USPTO was commanded by Congress to set fees to cover their aggregate costs. And because when they had to go to district court to defend one of these rulings on whether or not someone should be able to get a patent, that cost so much more, they started to consider whether or not they needed to levy those fees on that patentee. So, Nantquest's argument, currently before the Supreme Court, matched by the Federal Circuit when they reversed en banc, and the argument that was put forth by the Eastern District of Virginia, is that we usually operate under what's the so-called American rule in American litigation, which is that each party basically pays their own way, and courts can't force a party to bear the other party's attorney's fees unless Congress has specifically stated otherwise. And because the phrasing is so ambiguous, all the expenses, they say that basically Congress didn't specifically state that attorney's fees could be one of those expenses covered. And they also say basically we have a long-standing precedent applying this particular statute. Nobody has paid for expenses, attorney's fees expenses before. We shouldn't be paying for them now. On the other side, the government and the not en banc Federal Circuit argued that basically, hey, attorney's fees really are the bulk of the expenses here. And so they should be included. And if we don't include them, then the USPTO is just basically going to have to shift this expense to other applicants, successful applicants, raise prices for everyone. We should be levying these fees on the people that decide to go to the district court and fight the government. Plus, and I thought this was sort of an interesting argument, they said the American rule only applies when you basically have two sides of a litigation, when fees can depend on the outcome. And here they said fees don't depend on the outcome. The USPTO is the only party, basically, that it's talking about when it talks about recovering all the expenses. So they say the American rule actually doesn't even apply at all, which I thought was kind of interesting. Okay, so the argument is actually in less than a week. So if you're interested in seeing what happens to this case, the argument is actually next Monday afternoon. What do we think might happen here? Well, again, we don't know, but we think SCOTUS has been pretty skeptical in some recent cases, in recent sessions, of awarding attorney's fees. There have been some recent cases where they've looked hard at attorney's fees and when they should be levied in certain cases. But SCOTUS is also pretty sympathetic to agency budget issues, and clearly this is hitting the issue, hitting the budget of the USPTO. Also, interestingly, this all the expenses language is not only written in the Patent Act, but it's also in the Lanham Act. And so I don't know, Gideon, you may be in the roundup. You may have to actually have something to say about it from the trademark point of view. But we should know more next Monday about maybe how they're going to argue this or decide this. Okay, our second case is Dext Media v. Click-to-Call Tech. This case has been going on since 2001. It's got a really, really long procedural history that I read through, but you don't have to know. But basically, all that you have to know is that the prior owner of Click's patent had sued the predecessor of Dex for patent infringement a long time ago in 2001. And because of some acquisitions, the case was actually dismissed without prejudice, and they buried it for 11 years. The patent then got sold to Click, and Click sued the predecessor in interest to Dex again in 2012. The defendant attacked the patent, basically, and filed for this inter partes review procedure, which basically says, hey, USPTO, please look at this patent and tell me, because I think this patent is invalid, do you think it's also invalid? Because if it's invalid, then I can't be an infringer. So they filed this administrative procedure for the USPTO to look at the patent again. At that point, the PTAB, the Ptab, which is the part of the USPTO, administrative court of the USPTO, invalidated the patent and basically wiped out the infringement case. Well, the owner of the patent, Click, claimed this was completely unfair because you can't file an inter partes review administrative procedure more than a year after you've been sued for infringement. They said, hey, there was this prior suit. Okay, it was in 2001, but there was a prior suit a long time before 1 year, when they filed for the inter partes review. So then Dex, on the other side, said, we really like this result, and we actually think that the Federal Circuit can't review this PTAB decision. And I'll show you the statutes on the next slide in a second, but we've basically got dueling sections of the statute here. Well, the Federal Circuit, just so you know, reviewed it, and in Bank, they decided that not only did they have jurisdiction to review this inter partes review decision, but because of the IPR was time barred by that really old 2001 infringement case. Even though the complaint had been dismissed without prejudice, because it was filed, yes, more than a year before the IPR was instituted. Okay, that's a lot, so let me just show you the statute and then we'll sort of review what's going on. Here are the two sections of the statute that we're talking about. The first one, 35 U.S. Code 315, says that you can't institute an IPR more than 1 year after you've been sued for infringement. Okay? And then the second part, this is 314, says that you can't appeal the question of whether or you can't appeal the USPTO's decision to institute an IPR. Okay, this is a very procedural case. Are you following me so far? Okay. Okay, so the question really bubbles up to this. Did the Federal Circuit have jurisdiction to think about this again? Look at 314 here, no appeal. It says the determination by the director, which is referring to the USPTO, whether to file an IPR or not, has to be final and it's not appealable. But yet we've got the Federal Circuit saying they're going to weigh in and they're going to appeal it. So did the Federal Circuit have jurisdiction to consider the PTAB's institution of the IPR? They argued that actually they were not deciding on the appeal of whether or not the IPR could have happened. They said that they were actually deciding the question, on 315 grounds, not 314. They said that they were looking at it basically to see about the time bar issue. So that's the way they kind of got around the fact that they're not supposed to be looking at these issues on appeal. Okay, so the question that's before the Supreme Court is that question. Did the Federal Circuit have the jurisdiction to review the Ptabs decision to institute the IPR when it might have been time barred? Now, interestingly, Dex also asked them to look at that substantive issue about whether or not it was time barred at all, and the Supreme Court declined. So they're only looking at that jurisdiction issue. So I think that this is important because I think it may give us an indication about how they're going to rule, because it talks about why they took the case up. So I've read lots of articles that have come down one way or the other way. I tend to believe that the Supreme Court is going to overrule the Federal Circuit. First of all, because 70% of the cases they have taken from the Federal Circuit since 2007, they have overruled. So there's that. But also, some of the procedural history of this case that I didn't tell you is that this case has actually been going for quite some time and has been before the Federal Circuit twice and has actually been before the Supreme Court before. It went before the Supreme Court on this exact jurisdiction question in this exact case in 2016. And the Federal Circuit declined to decide, the Federal Circuit had declined to decide that jurisdiction question. That was appealed to the Supreme Court, and the Supreme Court sent it back. And they said, never mind about 314, that you can't look at it. We think that you can look at it, figure it out. Sort of opening the door to basically saying, you can look at it because of 315. You can look at it for the time bar issue, not whether or not they instituted the IPR. So because they vacated and remanded to the Federal Circuit to reconsider, granting cert now with new justices might signal that they're going to actually change course from what they had said before. I think it's notable that they granted cert even though there was no circuit split. I think it's notable that they granted cert even on just the procedural grounds, not the substantive question, because basically they may be indicating here that the substantive question doesn't matter because they're going to rule that the Federal Circuit didn't have the right to appeal this, to see this case anyway. They didn't have the right to hear the appeal. Okay, so what's the effect of this case? Well, if they affirm the jurisdiction, then that Federal Circuit ruling on the substantive merits is going to stand, which basically means that even a case that was filed 11 years before that had been dismissed without prejudice could keep you from being able to file an IPR and challenge the validity of a patent. But if they basically say the Federal Circuit was not supposed to have heard this appeal, then there's kind of a little bit of a question mark. Do we go with what the USPTO has traditionally said, or do we go with what the Federal Circuit basically said when it ruled on the substantive merits of the case? It won't be precedential, but at least they gave an indication of that question. Okay. I want to talk just really quickly about the Stronger Patent Acts of 2019 and then turn it over to Christopher. This is an act that's actually before both the House and the Senate. It stands for Support Technology and Research for Our Nation's Growth and Economic Resilience. So if you can guess what this act is supposed to support, it's very pro-patent. It's one of several patent reform bills, as I said before, that is currently pending before Congress, but this is the one that's actually made the most progress. And there are identical bills on both the House and the Senate side. There have been recent subcommittee hearings. There was actually a Senate subcommittee hearing on September 11th. They got a little press, and so maybe you've seen some writing about this. But basically, it's overall designed to strengthen the power of issued patents because of late, over the last couple of years, there are a number of ways that you can challenge issued patents, and some people are saying that undermines our philosophy of trying to incentivize innovation by giving people these government-mandated monopolies called patents. And so this act tries to sort of counterbalance what some people have said has been an attack on patents in the past couple of years. How does it do that? Well, there are three parts of the bill that people are discussing a lot. These IPR procedures that I've just been discussing, basically it makes it harder to institute and win those attacks on valid patents. It's harder to file an IPR, it's harder to win an IPR by level of evidence, by your standing. It limits multiple attacks, through IPRs. So basically, it looks at the IPR system, that inter partes review system, and it weakens what the IPR system says that you can do. Second, it talks about how easy it is to get a patent, an injunction for patent infringement. There was a case a couple of years ago called eBay that basically changed the way that injunctions were awarded in patent infringement cases. And this Stronger Patents Act would change that law to presume that infringement causes irreparable harm and that the remedy at law is inadequate, so it will make injunctive relief more common and easier to get. And third, it addresses what we call fee diversion. The USPTO has suffered from fee diversion, and it would actually give the USPTO more control over its budget and the money that it has. Opponents to this proposed legislation talk about IPRs in very glowing terms, especially as concern drug patents, which people they think that there are many drug patents that should be invalidated and that the IPR system allows that to happen. So opponents to the proposed legislation say that this is the wrong way to address patent reform. I don't think that this act is going to pass in this Congress. I think that Congress is busy with a few other things besides patent reform, to quote Christopher Yu. But because the Stronger Patents Act and related acts have come up before Congress now for 3 consecutive sessions, I think keep this in the back of your mind. There's definitely some congressional bipartisan appetite to look at our patent system and to try to legislate around that. So we may see something like the Stronger Patents Act come back again next term. Thank you.
Cindy, what could be more important than tech law reform that could occupy our Congress right now? It's kind of hard to imagine. So I get to play cleanup. I'm going to talk about some antitrust issues. There's a big net neutrality decision that was handed down yesterday. And I'll also talk about Oracle versus Google, which is the $9 billion case that has been fascinating Silicon Valley. So starting, that's what I just said. So starting with the tech law and antitrust, you've probably seen that Google's been suffered through 3 EU cases. The fines now total $9 billion US. That has the remarkable ability to focus the mind, certainly focuses the interests of practicing lawyers. What's interesting is they're actually talking about, one, they're bringing a 4th suit against Google, and there's an interaction between government suits and private suits, and I think that what you hear is all those private bar attorneys. EU recently instituted private causes of action in antitrust law. In the US antitrust law, we've been trying to get rid of nuisance suits for a long time, and this is the careful what you wish for part of creating private causes of action that we'll see. Brazil actually just pushed through a Google shopping case recently, and interestingly, there's all these cases against big tech. Germany attempted to use what is now clear, antitrust law to turn what I think of as a garden variety data protection violation into an antitrust case. They're saying Facebook didn't violate its privacy laws, and that was something that hurt the market. They were pretty firmly rebuked by the German courts, saying, it's like saying, oh, you speeded, or you did something, you blew up your opponent's factory, that's an antitrust violation. No, we have criminal law to deal with those sorts of actions, and unless it raises to the level of actually harming the marketplace as a whole, that's not a violation. I always think of it, there's mere securities fraud, there's fraud in the market. If it's just mere securities fraud, you go sue them and you get your money back. only if it rises to a systemic level that it hurts the market as a whole do we have these sorts of concerns. But beyond the formal actions, there's so many probes going on right now, including by the US. The FTC and the DOJ have split up the major tech players. They've all launched investigations. Australia's put together a digital platforms inquiry, which they combined with an industrial policy inquiry about how to save traditional media, which is fascinating. Guess what happens when you put a competition policy inquiry with an inquiry about how to save an industry? You come up with a competition law justification for saving the industry. And in fact, the UK issued something called the Furman Report, led by a former Council of Economic Advisors to Obama named Jason Furman. And China, Taiwan, Korea, many other countries are doing this. And what I will tell you, when I go to the International Competition Network particularly, which is the big gathering of international competition law enforcers, there is an incredible rush to judgment. You cannot lose political capital by hating big American tech companies right now. And they're not going to let little things like law and facts stand in their way. And it's a really interesting phenomenon. So to explain why this isn't just sort of an ad hominem attack on them, for example, I look at the Google cases. The Google comparison shopping case, it goes to compares things like Google's comparison shopping competitors like Etsy. The primary evidence is Etsy shares went down. Everyone says of Google's competitors' shares went down because of this change in their practice. What a typical antitrust person would tell you is that is an ambiguous fact. It could be that they've done something anti-competitive, in which case all the competitors' shares go down. Or it could be they've built the proverbial better mousetrap and actually they're more attractive, in which case all their competitors' shares will go down. And there's a very simple test we use in antitrust to separate the two. If it's anti-competitive, the total number of e-commerce transactions should decline. If it's pro-competitive, they've created a better system, the total number of e-commerce transactions should increase. Europe never asked that question. And so there may or may not be a case here, but I don't think this is an obvious thing, I think, to most antitrust people. They didn't address it. I love Australia's digital platforms inquiry. Among other things, it's turned Rupert Murdoch into a hero in Australia, which is a very, very hard thing to do. And what's fascinating is they've actually done a bunch of things, like they declared that search engine advertising and social media advertising are different markets, because they want to declare that Facebook and Google are monopolists in two markets. Because if they're actually in the same market, you can't do that. But what's most interesting about their recommendation is we need more regulatory authority. And when I asked them, and I'm actually going to I'm going to the belly of the beast, I'm actually giving a keynote at their conference, so I'm going to tell them I think they're wrong, and we'll see what happens. What they said is, when they said we need more regulatory authority, I said, aren't you admitting that you can't show this was an antitrust violation under existing law? And they said, yeah, we were hoping people wouldn't see that way. But they basically admitted that's the case. And they don't, under traditional antitrust law, what Facebook and Google don't have isn't illegal. And when I talked to the people who wrote the Furman Report, and I asked them what they thought of the Australian report, and they said that British have a euphemism for this. They called it brave. And a friend of mine sent me an English to US English translation dictionary as a joke, and they said, brave means you're out of your mind. Just like saying, I have a few small changes for you means you need to rewrite this entirely. They have this remarkable understated way of saying it. But the funny thing is, I actually was on a panel with one of the authors of the Furman Report, and he kept saying, this isn't that big a deal. I don't understand why you're so upset. In fact, all the mergers that you're talking about would have come out the exact same way under our new standard. At which point I looked at them and said, so what was the point? The point is political, is my conclusion, is that in fact they're making a lot of gestures and you can't really go wrong that way. And what I would say to date, this hasn't really affected a lot of law. FTC versus Qualcomm. On May 19th, 2019, the district court judge in the Northern District of California said that Qualcomm's licensing practices for certain patents that have been incorporated, particularly into the 4G standard, violated Section 5 of the FTC Act, which violated antitrust law. Why? They agreed to license, as everyone who puts a patent of a standard agrees to license it on fair, reasonable, and non-discriminatory terms. That means anyone who wants to, as long as they're willing to pay a royalty set by the organization or that's compliant with the organization, can use the technology. Qualcomm, instead of letting anyone use it that was using the standard, followed a policy of no chips, no license. In other words, if you don't buy chips from us, we won't let you use our patent. Now, a standard should allow you to use anyone to use the patented technologies for chips manufactured by anybody. And so this is problematic. The other thing they said is, in addition, they required an exclusivity agreement. That is, not only do you license the patents, you have to do license the chips, buy the chips. You have to buy all your chips from us if you're going to get a license. Now, the question is not whether that's a bad thing. It almost certainly violates their contractual obligations under their FRAND commitment. The question is, does this rise to an antitrust violation? Particularly, and what happened was the court enjoined it, and we're going to have this go on further. Now, there's two facts of this case that are really, really interesting. Many people blame the entire existence of this case on Republican FTC Commissioner Josh Wright. Why? Because at the time, at the end of the Obama administration, there were 4 FTC commissioners, 2 Republicans and 2 Democrats, and as often the case, there's this whole flood to the exit doors at the end of an administration. Josh left. So even though there was a Republican, this is in the early days, this is the early days of the Trump administration, where they have the right to have a majority in place. Josh couldn't wait, and so he left, leaving a 2-1 Democratic majority in place during a Republican administration. In which case, they voted out the complaint, and then they appointed more commissioners who wanted to recall the complaint, but they couldn't. So that's a very odd thing, because if he had delayed his resignation from the FTC, this case would not have happened. Second, the U.S. Department of Justice has filed papers in the appellate court opposing the FTC's position. So you have 2 parts of the U.S. government litigating against each other. This is an artifact of independent agencies and the way we've done things, and it's a very, very odd phenomenon. And it's really strange because we do this in front of a backdrop of of patent law where you have no obligation to license them, and this is a very, very, very big deal. And people are fighting over this like crazy. And so this is going to be a major case about how it comes down. Many people think that this is a contract problem, that you should get contract remedies. The question is, can you get antitrust remedies? Our own Herb Helvenkamp has written something much like what I said about privacy. Contract violations generally aren't antitrust violations, but could become large and systemic enough that if you can show a harm to the market, that you can state an antitrust claim. We shall see. Oracle versus Google. Oracle has a bunch of copyrights in Java. Google entered negotiations with Oracle wanting to use all of these copyrighted software for use in the Android platform. Halfway through the negotiation, they said, you know what? We're not going to negotiate any further. We're just going to deploy it and sue us. Oracle sued them, saying that everyone else has used this, has licensed them for money. Why are you doing this? Lawsuit ensues for copyright infringement. 2 jury verdicts overturned by the Federal Circuit. First, the jury verdict says this is not copyrightable. Federal Circuit overrules. They then say, oh, it may be copyrightable, but it's fair use. District court jury verdict, yes, it's fair use. Federal Circuit overrules in March of 2018. Earlier this year, in I think April, it's pending on cert. The Supreme Court calls for the use of the Solicitor General, which is a very traditional thing to do. The Solicitor General's use rule almost all the time, and there's like 80-90% of the time. 2 days ago, the Solicitor General brief landed on the desk of the court advocating against certiorari, saying the Supreme Court don't take the case. As you know, the first conference is going to happen on Friday, that is day after tomorrow, and first Monday happens 5 days from now. At which point they will drop all the orders, and one of the big questions we have is, are they going to take this case? If they don't take the case, we are going to go immediately into a damages proceeding where Oracle is seeking $9 billion in damages from Google. If they do take the case, we're going to have another round. Okay. So copyright always presents this very strange paradox, which is, on the one hand, you can't copyright a method of operation. But on the other hand, Congress clearly intended software to be copyrightable, and all software on some level is just a method of operation. And so people have always struggled to figure out what we should be doing with this. And the big question is whether they've created a doctrine about, they talk about structure, sequence, and organization as the copyrightable elements of this, but no one knows actually what that means. And everyone's fighting over the scope of this protection. So if you want to know what's going on, they actually copied 37 Java packages, 11,000 lines of code. Google did. So the first question is, you can take the one position that that's problematic actually doing that. But what's even more interesting is, they're also saying, okay, even if we weren't going to copy the code, we need the structure of the code. We need the names of the files, as you call them, the command system, for purposes of interoperability. And speed to market, we could do something, but it would take longer. So even if you're going to give them, you can't steal 11,000 lines of code. That's an infringement. Can I borrow the naming structure of how you call all these things? Is that copyrightable? And the way the Federal Circuit's looked at it and said, oh, the second author had tons of choices of way you can do this, but in fact, in a larger system, that's very, very hard to do on an installed base. And the other question is the fact that it'll be faster to market or more interoperable a legitimate justification for fair use? And these are big questions under copyright law, which we don't have answers to. Last thing. 2 days ago, the DC Circuit dropped its most recent decision in the network neutrality decision. And the headlines, and it's funny, the New York Times has picked it up one way, as a resounding victory for the Trump administration and people who actually oppose network neutrality. That is one way to interpret the case. And if you read the first 2/3 of the case, that is clearly what it's saying. The last third of the case is dynamite. Let me explain why. So just in the history, Obama, the administration, passed the 2010 order basing network neutrality as a fairly modest intervention on a limited statutory basis called Title I, got reversed. In 2015, in response, they repassed the rules, much more searching rules, on a stronger statutory basis called Title II. That was upheld. And this is all in the backdrop of a Supreme Court case that says the first limited basis is legal. And in 2018, the Trump administration's chairman passed through another order returning to the more limited basis that was originally part of the 2010 order, also upheld 2 days ago. And they won in almost all the cases. This is an example of how administrative law works in the US. It's deferential review. As long as it's reasonable and you turn nice and make a justification for it, you're going to survive. So this is within the zone of reasonableness where you can do it one way or the other way. It's legal, but it's almost a guarantee that every time the White House changes hands, we're going to get a new rule. And that's pretty clear after this case, but that these rules are going to stand. They remanded on a very, very small number of things, public safety communication, poll attachments, and lifeline, leaving the rules in place, this universal service, letting them rethink it. They will clean that up without breaking a sweat. They'll just, consider it and think about it, and they'll be done. Here's the big part. At the same time, the 2018 order deregulated most of this. They also included part of the opinion, part of the order saying we preempt state law. So not only are we not requiring this, states can't do it. California, being California, said, oh, you can't tell us what to do, has passed legislation essentially reenacting the 2015 order from the FCC. And what you see now is in the last part of the order, the last third of the DC Circuit's decision, they said the FCC lacks the authority to preempt state law. So what you now see is that what has been a federal regulatory debate largely coming to an end, and it beginning as a 50-state capital fight that will be largely legislative. It could be administrative, but it's largely legislative. And that's going to be, and the outcome is going to be conflicting rulings of rules. Now, I don't mean to make too much of that. We do tort law, we do 50-state law for almost all contracts, torts, we still survive. Breach notification for privacy is 50-state law. It's a pain in the ass, it increases cost, but we do manage this in some ways. But the interesting question is what's going to happen. State legislatures are much more susceptible to special interest defensive operations or offensive operations across 50 states, it radically changes the political economy of this. And we're going to see very, very different valences in how all this plays out. What could happen? The full DC Circuit could take this en banc to reconsider the preemption decision. I'll tell you, I think that's unlikely. The Supreme Court could take it. I think that's also extremely unlikely. These are not the kinds of cases this happens with. The FCC will probably try to reinstate its preemption ruling on a different statutory basis, which they can try to do, but they took their best shot already, and my guess is it's going to be a reach. Or you can let Congress do it, and for the reasons Professor Dahl's already said, that ain't going to happen. And so it'll be very interesting to see how this plays out. There is a very real world in which we're going to see a 50-state rugby scrum over how all this is going to play out, which may or may not be good depending on how you think about things, but actually for lawyers, particularly the lobbyists on state legislatures, they're delighted. All right? That is the end of our presentation tonight. We would welcome any questions you might have in the minutes we have. I know you're just being shy, because I know many of you out there, and there's no way you don't have a question. Andrea.
I actually have two questions. One for Professor Paczynowski. You mentioned that you think that willfulness should be there, should be present, and so I was wondering whether you could expand a little bit on that. And the second question is for Professor Hughes. You mentioned the possibility of this turning into a 50-state food fight. That wasn't possibly your word, but that was the concept. Don't you think, looking at it from a slightly more positive light, don't you think that this could open the door for a solution along the lines of what was done with UCC? For the possibility of developing something via organization, groups of experts, then adopted uniformly across states?
So thank you very much for your question. And here is why I think that willfulness is required in this case. We're talking about disgorgement of profits, which is an equitable remedy. And there were two parts there to the jury decision. There was the 90,000 part that was supposed to represent the profits that Fossil actually accrued, and then the 6.7 million part, which the purpose of which was to create deterrence and take care of, the possibility of future infringements. Now, when it comes to such remedies, traditionally, the trigger was willfulness, and I think that this is good. What is callous disregard? We're getting into shades of inequitable behavior, but we still haven't reached that bar of willfulness. And I think that it's critical to keep it there if we are honest about what it is that we're doing. If not, courts will have a lot of discretion. Again, it's wonderful for litigators because you can ask courts to grant you remedies without a showing of willfulness. But I always believe that certainty is an important part of the law, and to the extent possible, we should maintain it. And therefore, my personal hope is that the court would adopt the position of the Second Circuit, the Ninth Circuit, and would insist on willfulness. Whether or not it will, I gave you my prediction, but this is my personal opinion. And again, thank you for your question.
The happy situation you're suggesting is optimistic. My diagnosis of the political economy of the network neutrality debate is the main proponents have changed over time through three different corporations. In the beginning, it was Microsoft, then it was Google, then it was Netflix. All of them are realizing that they are now targets for search neutrality, device neutrality, you name it, and that the same principles apply. And they've all sort of let it go. And in Netflix, most recently said we can live without it. The most interesting the other major part of support is coming from foundations to NGOs. Ford Foundation, Sloan, Soros, a bunch of others. I may not have them all right, but there's a lot of foundation money. They have been telling the NGOs that receiving that money that if their continued support depends on their not compromising in this battle. And so when you attempt to get middle ground discussions, they tend to go south very quickly. And some Democratic congressmen raise money on this issue. And so there's a number of people who don't necessarily want this to go away and don't want it to go. I think there is a middle ground. I don't know that they want it to be found. Plus, it's interesting. Everyone's much more interested in privacy right now than they are about this. People are tired of it. Go ahead.
My question is on who owns the internet, since it was paid for by American government research. This was paid for by the people of America in terms of this net neutrality issue, because it is in effect a common carrier.
So it gets very complicated. First, the government put the research together for the protocols, but the vast majority of since '95, we privatized it. And so almost all the investment in the internet itself is private capital. And so they essentially created the system that allowed all of us to connect and showed us the way. But the notion that it is public money hasn't been true, and the fraction of it that still is essentially none, because those things are all gone. The interesting question is it a common carrier? There's a long fight over what things we should regard as common carriers, mostly encapsulated by fights over media should broadcasting be a common carrier? Should cable have been a common carrier? The answer in both those cases ended up being no. But what's even more interesting to me is in this world of, we forget that in the 1980s, there was an incredible movement to say that common carrier regulation didn't work very well, that we've kind of forgotten, and that in fact, we were trying to get out of that mode for FCC, NTIA, all these government things, because it facilitates collusion, it actually hurts innovation, all these other things, it increases prices. And people were very skeptical of traditional common carriage regulation, and there's an old history that's sort of been lost. And so I think we need, instead of looking to we're the only country in the world that didn't fold the internet into old regulatory models. We try to create new ones. And we end up having much, if you look at the numbers, much stronger deployment and much larger investment, say 2.5 times what Europe has per household. And that I think we should actually be looking for new models, not looking automatically at the old ones. Not everyone agrees with me. We are off over time. I'll give you the last question.
Okay. Well, I had a quick question on antitrust. I hope you'll forgive a question from a relative newcomer to that space. You mentioned that the EU is not asking the question of whether the total number of commerce transactions is increasing or decreasing. Have other people asked and answered that question? And are they not asking it because it's difficult to econometrically disentangle the particular action that Google's taking from anything else that's been going on in the market?
So the answer to the first question, are the people asking the question? They're asking it. The better question is, are people answering it? I don't know. I suspect that they are. But all these things are being appealed. I strongly suspect that it will go into the appeal, and the easiest way to find out is to look at Google's filings, because that information actually is not that hard to come by. Because it is, only problem is you have to pay for it. It's collected by private data companies. But I think we can answer that question. But it goes into an old saw that everyone says, but people don't always honor. Antitrust is about protecting either, we say, consumers, not competitors, or protecting competition, not competitors. And so there are many things that we assume that just because it's bad for a competitor, it must be hurting the market. Well, building a better way of doing things is very, very bad for your competitors. Efficiency is extremely bad for your competitors. And these things, and what we really need is a lens to look at pro-competitive activity versus anti-competitive activity. And adverse impact on competitors can be a useful indicator, but might not be. And so we need to develop tests that untangle them. And your point's a good one. Simple tests that judges can understand. And things like quantity is one of them. These big fancy rules we do sometimes, policymakers have told me a long time ago, simple facts convince people, complicated ones don't. And so you really do need to reduce it to something that is more tractable. Before I close, any closing thoughts from anyone else on the panel?
Thank you.
Well, we'd like to thank all of you for joining us.